I think we are pretty much ready. So I'm Greg Brimblecombe. I'm one of the newest lawyers at SBA, but the oldest lawyer at SBA. I started out as an adjuster back in the very early 80s, went to law school in the 90s, and I've been practicing now for 25 odd years at the same location until Friday. And on Friday, we're moving to a no location in Kitchener. My practice is solely insurance defense work, but no AB. I do a lot of tort, a lot of subrogation, a lot of property. I also act as an umpire in Insurance Act appraisal matters. For those of you who are unfamiliar with SBA, again, strictly a defense firm, all facets of defense, fraud, AB, tort, motor vehicle. We apparently have 3 offices. I'm not really sure about that. I've only heard it as a rumor. But we do know the Kitchener office is by far the strongest and best office. The others are very good, I'm sure. I wanted to tell you as well that the presentation's being recorded today, and you can go on the SBA website if you're compelled to view it again, or if perhaps I screw up badly and you just want to have something to laugh at. There's slides that I'm going to be referring to, assuming I can make that work. And those slides will also be available. Just reach out to me by email and you'll see my email on the screen here, and I'll show it again at the end. We have questions section at the end. You can write in the chat box and I'll endeavor to answer your questions. And if I can't answer them today, I'll get to them and answer them by email. And I got to tell you that this is unusual for me doing a presentation like this. I've done lots of presentations, but I can normally see people and I can interact with them. So I'm feeling a little bit strange doing it this way. With no further ado, we'll get going. Today, we're going to be talking about the CGL in the context of the work product exclusion. I decided to do the work product exclusion because it's a rather convoluted walkthrough of the CGL, and that's what I really want to get at, is how do you walk through the CGL? We'll answer the work product exclusion question as we go, but the real takeaway for this should be, how do I walk through the work or the CGL? In order to do that, I picked a scenario, and my scenario is on a screen that I have to figure out. There we are. We did it. Here's our scenario. The insured's a general contractor. He did a significant amount of the work with his own forces on a commercial building, but he didn't do the windows. The windows he subbed out. There's an allegation now being made that the windows were improperly installed. There's no allegation in the claim that suggests that there's any resultant damage, but that the windows need to be reinstalled, or there could be resultant damage, and if they're not, then there is going to be a concurrent loss of value of the building. I can tell you that with the CGL, a lot of people, lawyers, me included, can be a little intimidated by going through the wording. It can seem awfully convoluted. The hardest part I find is jumping back and forth between the various sections of the CGL and the interplay in particular between the exclusions and the definitions. So what you'll find is that there are inclusions to the exclusions and exclusions to the inclusions, and the whole thing kind of reminds me of George W. Bush's old Vice President Dick Cheney when he said there are known knowns, unknown knowns, and unknown unknowns, and that's kind of the CGL. As I said, I chose this scenario because it seemed to me that it would give us a good chance to go through a number of the sections of the CGL and see that interplay. We are looking to determine whether or not there is coverage under the policy, and what we have to understand is that there are 2 distinct reasons to find coverage. One is, do you owe your insured a defense to the action? And then the second step is, do we owe an indemnity? So what we're really looking at today is, do we owe a defense? The issue of indemnity would probably come later. I'm going to talk a little bit more about the owing of a defense later in the presentation. But for now, that's our quest. We're looking to see whether or not we owe a defense to this claim. So the first step that we want to have in our exploration is, when you get the claim, you want to ensure you've got a policy that's in effect and it has the appropriate coverage. So you get this claim reported, you take a look at your deck page, and you don't see any CGL coverage at all. That might end the whole thing right there. But let's assume, for the purposes of today, because it'd be a damn short presentation, that there is a CGL policy. Then you got to determine what section of the CGL policy is going to apply to this loss. There's 4 sections essentially to most CGL policies. There's the bodily injury and property damage section. That's number 1, and that's where the bulk of claims will fall. The second is personal injury coverage, which is kind of like a libel and slander coverage. The third one's a med expense payment. I really don't know what it's all about because I've never seen a claim under it, but you know, we're not worried about that today anyway. And the fourth one is tenant's legal liability, which is essentially any damage done to a rental building. And the reason that's distinct is that there is an exclusion in the CGL for care, custody, and control. So that brings the coverage back in there. So by process of elimination today, we know from our scenario that there's an allegation being made that we have property that may be less useful or less valuable as a result of an alleged wrongdoing. So we can assume we have a property damage claim that's being made. So section 1 of the policy. The CGL is, and I'm going to address this a little later as well, not unlike any other policy. It's not unlike a property policy. There's a grant of coverage, the insuring agreement. There are exclusions, and there are definitions. There's other sections of both property and the CGL policy that we're going to ignore for today's purposes, including limits of insurance, conditions, the definition of insured, those sorts of things. We're just sticking with the 3 main parts for today are the insuring agreement, the exclusions, and the definitions. So knowing that we're looking at a property damage, we have to look and see what is the potential insuring agreement and what's it going to tell us. So there's the insuring agreement. I don't intend to read it to you because you can read faster than I can talk. But what I want to point out is you're looking for amounts that you'll be legally obligated to pay as compensatory damages because of property damage. There are quotations around compensatory damages and property damage because they're defined terms in the policy. Legally obligated is not a defined term in the policy. There's another requirement that it has to have been caused by an occurrence. And there are a couple of key things that I want you to take out of this. You're looking for legally obligated. It is, would a court award damages against your insured? That's what would make them legally obligated. Now, of course, you don't need to go to trial to figure that out every time, or it would be incredibly expensive, although I would like it because it would mean a significant amount of more work. But if you use your common sense and you think, you know what, at the end of the day, a judge would be likely to award damages, then we may be legally obligated. Legally obligated, however, does not include things like punitive or exemplary damages. I wanted you to take a look at the insuring agreement because I want to point out to you, this is sort of a sidetrack thing, that it makes no mention of negligence. Often we get stuck on a claim or a claimant having to prove that there's negligence or that the claim arises out of negligence, and that's just not accurate. We're looking at the concept of legal liability or legally obligated. And legal liability can arise in many ways other than negligence, and I would point to the Dog Owners Liability Act. The Dog Owners Liability Act makes you strictly liable for any attack by your dog or any bite by your dog. There doesn't have to be negligence associated with it. And under a homeowner's policy, of course, that would be covered even in absence of negligence. So keep the concept in mind about legal obligation as opposed to negligence, because there are situations, for example, where contracts are covered under the CGL. Also on a sidetrack thing, we're dealing with a property damage claim here, and it helps me to think of it kind of as a noun. So when I'm looking at it, I ask the question in my head constantly, is this a property damage? Not is there property damage, but is this a property damage? Can we call it that? And then we got to figure out, how do we get there? We're going to then go through the coverages to figure out whether this is a property damage and whether it's covered by taking a look at the wording. We know that when we're looking at the insuring agreement, we have some defined terms. So why don't we go there? The next term we're going to look at, or the first term we're going to look at, is property damage. You can see that up on the screen. And what I can tell you is that property damage includes loss of use of property, loss of use of tangible property that's not physically injured. So here we have the loss of use of the windows, or perhaps even the whole building, because the windows are improperly installed and or the building is now less valuable. I would suggest that that meets the definition of a property damage. So we are okay, we have a property damage. The next step, looking back at the grant of coverage, is, are they seeking compensatory damages? We talked about that a little bit, and we said that property damage or compensatory damages don't include punitive or exemplary damage. Based on our understanding of how this claim is being put forward, we'd suggest that they're looking at compensatory damages. The next thing from the insuring agreement that we have to decide is this an occurrence? And that's maybe a little bit more difficult question. We'll go to that. There is a case called Progressive Homes that talks about what an occurrence is. And the insurer took the position that it's not faulty workmanship. This went to the Supreme Court of Canada, and the Supreme Court of Canada said, well, an occurrence is something that's not expected or intended. So if it is unexpected and unintended, then it can be an occurrence. Went on to say that since it wasn't alleged that it was an intentional conduct, but rather it was a negligent conduct, it would be within the coverage provided under the policy. So looking at our analysis, we now have a property damage by definition. We believe we have compensatory damages, and we believe we have an occurrence. This may be as good a time as any to talk about how the courts interpret policies as a whole, not just the CGL. So the courts have said, the Supreme Court of Canada has said consistently that the grant of coverage, the insuring agreement, is to be interpreted broadly. That is, if it's possible for it to be covered, it should be covered. And then they go on to say that exclusions should be interpreted narrowly, meaning that if there's an exclusion and there's any doubt as to whether or not it applies, it does not apply. This kind of makes sense in a way, because insurers or insureds are buying protection, and they're paying for peace of mind, essentially. And if the policy is interpreted more narrowly, it gives them less peace of mind. It's also the insurer is writing the policy, and they can make things clearer or unclearer as they see fit. And if they choose to make them unclear, then they're going to bear the responsibility of that. Those are comments that probably should be directed to your underwriters. And if you want, I can talk to them. Not that they would potentially listen. So I want to go back now. That was a little bit of sidetrack. Going back now to our analysis. We've now determined that the claim would initially grant coverage under the insuring agreement, that is property damage, compensatory damages, etc. You're going to say, well, hang on, policy's not a warranty. You shouldn't have to pay for faulty workmanship. And that position is kind of true. What we're going to look at is a case called PCL contract or constructors versus NCON. In that case, NCON built the whole building and there was a problem with it. And there was a motion to determine coverage. And what the Supreme Court of Canada ultimately said is you can't exclude the whole building because essentially that wouldn't be fair. What would be reasonable is to exclude that part of the problem that directly relates to the work being impugned. So it's right that the policy is not a warranty, but it's not an all-encompassing thing. And I'm not going to say much more about that because it would take up a lot of time. If you're interested, give me a call or an email. And if you've got a claim that is bouncing around this area, don't be afraid to reach out to SBA and talk to us about it. Once we've decided that there's a grant of coverage under the insuring agreement, we now have to look at the rest of the policy and see if there's anything that might impact that. The next section that we come to, and I would always encourage you to go through the policy in order. There's a reason that it's been set out in the order it's in. Best is to go through it that way. So we next come to exclusions. The first exclusion that will catch your eye probably is the contractual liability exclusion. And that exclusion, you can see it on the screen, you might say would apply because there would be a contract to build the building properly, and the contract was breached because it's alleged that it wasn't built properly. But you'll notice that the exclusion doesn't apply if there would be liability even in absence of the contract. So in this situation, one of the allegations may be, well, it's a contractual obligation, it's not covered, but there's also an allegation that the windows were installed negligently. So the contractual liability exclusion isn't going to do you any good. As you work your way down the exclusions, the next one you're apt to come to that catches your eye is the damage to property exclusion. That exclusion seems promising. When you see it, it excludes that particular part of real property which you or your subcontractors are working on or performing operations. What you'll see in that exclusion, though, is the wording that the exclusion is the work you are in which you are performing operations. So the concept of this exclusion is that it would apply while you're doing the work. This claim is being made after the building was occupied and being used and the insured's work was completed. So now you're thinking, okay, well, that one doesn't apply. Am I ever going to find anything? So you move on to another exclusion that exists. And I'm sorry, I didn't put this slide in, the damage to property exclusion. But when you see it, it's a very short exclusion. What you'll see is that damage to property exclusion doesn't apply to anything that's included in the products or completed operations hazard. So the damage to property exclusion says, if your stuff is damaged, it's not covered. However, it might be covered if it's included in the definition of products and completed operations. This is kind of a good thing for the purposes of this seminar, because what it does now is it starts to show you the interplay between the exclusions and the definitions. So you're going, okay, I got a damage to property exclusion that may or may not apply. I need to go into the definitions and see what a product or completed operations hazard is. And there it is. It magically appears on the screen. The product and completed operations hazard tells us that a product or completed operation is damage that occurs away from your premises, and that's true in this case, and arises out of your product or work. That's true in this case. You built the building, and now you're thinking, okay, well, maybe this is going to be covered. Maybe our damage to property exclusion doesn't apply, and we may have to cover this loss. There are more exclusions and parts to the products and completed operations section. We won't bore you with this because we think that this section does apply. So is there another exclusion besides the property damage exclusion that applies? Because in this case, it looks like it won't apply. Moving forward, we come to the your product exclusion. Again, a really simple one and easy to follow. The difficulty you encounter here is that the claim isn't being made as a result of your product being faulty. So if you supplied the windows, nobody's suggesting that the windows are faulty. They're saying the installation is faulty. That exclusion won't apply. That doesn't help you. The next exclusion that may catch your eye is the damage to your work exclusion. And it's property damage to your work arising out of any part of it included in the products or completed operations hazard. So now the products and completed operations hazard kind of flips around, and it helps you here if you're looking to exclude it. But once you get excited about the fact that, hey, maybe this is a damage to your work exclusion, you read a little further down the exclusion and you'll see that it doesn't apply to damage or the work for which damage arises if it was performed by a subcontractor, which is the analysis in this case. What we've done then is we've looked at the insuring agreement, we've looked at the exclusions, and we've looked at the interplay in the exclusions to the definitions. And what we've done is come to the conclusion that there's probably not an exclusion that's going to apply to this fact scenario, and that you're going to end up potentially with coverage. What that means is that you probably owe your insured a defense, and there's a difference between a defense and an indemnity. We have in our situation right now, like I said, a grant of coverage. We know that there was initially an exclusion because it arises out of a claim made before your work. That was reintroduced to coverage by the products and completed operations hazard, which is then excluded under the damage or the work product exclusion, which was then brought back into coverage by virtue of the fact that there's an inclusion to that exclusion that the work was performed by a subcontractor. All very confusing, but it kind of makes sense, and I can go through it more slowly later. So now, like I said, we know we have a duty to defend the action. The duty to defend was something that was discussed by the Supreme Court in a case called Nichols and American Home. There, the court held that the duty to defend arose, I can find it, there we are. The duty to defend arose when the claim made against the insured, potentially, being a key word, falls or may be argued to fall within the terms of the policy. That doesn't mean that you gotta decide that there is absolutely unequivocally coverage for indemnity, but provided that there is a potential for coverage for indemnity, you owe a defense. They went on to say that when they examined the pleadings to determine whether the duty to defend exists, and the widest possible latitude should be given to the allegations in the pleadings. So typically you're not looking at extraneous evidence in making this determination, although if the pleadings are deficient, they will look at some extraneous information. Essentially though, the court preferably would be looking strictly at what the statement of claim says and comparing that to what the policy wording says. The statement of claim may or may not be issued when you get the claim reported to you, and I would suggest in more cases than not, there is no statement of claim. Your insured simply phones the broker or the agent and says, I heard from somebody who's dissatisfied with my work, my product, whatever, and they've indicated they're going to sue me. So without having a pleading, you're trying to make a decision. And you just use your noodle. Give some thought to what will likely be pleaded based on your experience and how that interplays with your statement of claim. And again, if you're having difficulty making that determination, pick up the phone a defense lawyer, hopefully one at SBA, but find somebody that you're comfortable with. when you're determining whether or not there is a duty to defend, the court set out essentially 7 things that you should be looking at. And there they are. And I will walk through them with you very briefly. It's separate and broader than the duty to indemnify. And we've talked about that. There may not be a duty to indemnify depending on what happens as the claim flushes out. So, for example, in our scenario, we find out later on that in fact your insured did install the windows. So there would be no duty to indemnify. The duty to defend was manifested out of the pleadings, and it was appropriate at the time to pay the defense costs, and you're stuck with that, but you don't have a duty to indemnify. One caveat to that is if your insured's been lying to you, that could change the whole thing. The duty to, or the pleadings govern the duty to defend. We talked about it. The duty to defend extends even where the claim may be groundless. And that makes sense, right? So your insured bought a policy that says, if somebody sues me, you're going to defend me. That's part one. And if I'm responsible, you're going to pay the indemnity. So what happens in a situation where your insured clearly didn't do anything wrong but still got sued? Wouldn't be fair to them to have purchased this policy for protection, and the insurer says, well, sorry, it doesn't look like you're liable, so we're not going to defend you. Widest latitude should be given to the allegations in the pleadings. We talked about that. It's not necessary to prove the insurer's obligation to indemnify will in fact arise in order for the duty to defend to be triggered. That's redundant, but the Supreme Court of Canada is often redundant, and we talked about that earlier up. We talked about this too, the mere possibility that a pleaded claim may succeed within the terms of the policy is sufficient to trigger the duty. So just a mere possibility that this thing could be successful, even if it's outrageous, gives the insured the duty, or the insurer the duty. Where it's clear that there's no coverage and the claim falls outside of coverage, of course, there's no duty to defend. So that's the duty to defend the discussion. When I started, I think I told you a little bit about what I was hoping to tell you, or what I was hoping you would take from this. I'm now essentially done telling you what I wanted to tell you, and I want to give you what I think would be good takeaways from this. First, don't be afraid of the CGL wording. Like I said, it's kind of like any other coverage or any other wording. It's got a granted coverage, it's got exclusions, and it's got definitions. Next thing I'd like you to take from this is when you're going through the policy, the first step is to deal with the insuring agreement. Is there a property damage? Is there a bodily injury? Is the third party seeking compensatory damages? And is there an occurrence? I didn't put that in, but that's the first step. The next step I want you to take through is going in order in the policy, look at the exclusions. And then as you're going through the exclusions, you have to make reference to the definitions as you need to. For this, I'm old-fashioned, but I think it works. Get a scrap piece of paper and a pen and make notes. Easy to keep track that way. Sometimes the case law or the wordings are unclear, or they're difficult for you to understand. They're difficult for a lot of people to understand, and reference has to be made to case law. When that happens, I'm going to suggest you might be time to phone a defense lawyer for a coverage opinion, and hopefully that's somebody here at SBA. Those are my comments. I will take some questions. What I've done is I've outlined the screens. So there's an outline here, and it's in the presentation. You can pick some or all of the screens if you want us to send them to you. Questions, apparently I can find something in my Zoom call that will help me identify where there's questions, but I don't know how to find it. And I think we're pretty much out of time in any event. So what I'll encourage you to do, email me any questions. There's my email address right there, gbrimacombe@sbalawyers.ca. And I will answer them, and I will try to get the answers to you today or tomorrow at the latest. I want to thank you for listening to me. I know this has just been horribly compelling to listen to the CGL and me drone on about it. But I will say, as compelling as my presentation was, it's going to be nothing compared to the coming attractions. So next month, Lisa Code, one of my former partners at McCormick Haney, is presenting on vicarious liability. It is all about possession. Lisa is dynamic. She will be amazing. I'm going to build her up to no end, and then she's going to come over and slap me upside of the head for making it sound too good. But really, she is very good at analysis and explanation, and I'm sure you'll take a lot out of it. And then the one in December is Carolyn Meyer, who is equally as good or compelling as Lisa, and she's going to tell a compelling story about litigation. So thank you again for tuning in. I want to thank a couple of people. I want to thank Lisa Code, because I stole a lot of the information that I used in this presentation from her and a reporting letter she did a few years back. I want to thank Harrison, one of our articling students, for putting together some screens. And I really want to thank my assistant, Gail Campbell, without whom I clearly wouldn't have a career. Thanks, everybody.